Hi, this is Brian Ka with another video to help you pass the California baby bar and the bar exam. So we're going to do another remedies question. By now, you should be sick and tired of doing these remedies question. And I think that's the point where you want to be at. Because as I've said in the previous video, from my own experience, I don't think that the bar exam is necessarily testing how intelligent you are. I mean, in a way, they are, but the majority of what they're testing on is whether you've practiced enough and you've done so many of these questions to the point where it becomes like a second language for you. I've made an analogy in the previous video about how learning, for me, if I wanted to learn Japanese, it's going to take repetition after repetition. And by the time you practice so much and make it like a second nature type of language for you, it will be very difficult. But once you start mastering it to the point where you're doing it like you're breathing or eating, it just becomes so much easier versus when you're first trying to learn. But one thing I gotta say though, whenever I have to start a new subject in law school, in the beginning, it takes a lot of work because these are concepts that I've never even heard of. I've never, studied them before, even in college. A lot of the things now for me as a third-year law student are repetitive, but there's still things that are not repetitive. They're, brand new subjects, and it takes me around a month to study the outline every day and do every single practice question that's ever been administered around 2 to 3 times. And I've learned from my experience that after doing each of these questions around 2 to 3 times, and for me to record these videos, I have done them probably like 6, 7 times by now. And I think there are like more than 10 questions for remedies because this is a subject that the bar loves to test as well as professional responsibility. So, again, I would advise you if you're struggling with remedies to practice writing. If you don't want to write, make sure to practice outlining. In many cases, I think that outlining is sufficient because if you have to write the entire test, and there are so many tests that you have to practice, it's going to take a long time. But outlining them refreshes your memory because we have to learn so many subjects and around 30, 40 major rules of law under each subject that our brain capacity sometimes explodes. But in order for us to organize that in coherent ways, we have to just keep practicing and make it as second nature to what we do every day. So here is another one from July 2024, and this is question number 5. Now, number 1 is saying, what damages can Perry recover, right? What damages can Perry recover? Now, I'm not sure if they're talking about, legal damages. I'm not really sure if they're talking about equitable remedies, but usually when they're talking about damages for the purposes of California bar exam, they're referring to legal damages, money, right? And number 2, it says, what equitable remedy or remedies can Perry obtain? Discuss. Now, we discussed this in the previous video, and I made a mistake of leaving out two major equitable remedies. I'm not sure why I forgot, but the first two are rescission, reformation, temporary restraining order, preliminary injunction, and permanent injunction, and specific performance. And under the umbrella of unjust enrichment, there are two types. One of them is um, the second one is equitable lien. And the first, I just had a brain fart, but the first one is uh, constructive trust. Now, there are two more which are not popular, but they do appear, and they're replevin and ejectment. Now, I'm not trying to say that like I have mastered this. Obviously, I have a long way to go, but I didn't look at my notes when writing this. Meaning, whenever I see a question that deals with equitable remedies, I already know in my head that these are what's available to me. And if I were to represent a client, I would suggest, any of these depending on the facts. Now, for damages, as you know, we talk about things like expectation damages, compensatory, consequential, incidental, reliance, unjust enrichment, restitution. Sometimes there are punitive damages if it applies. So, using these outline, I didn't write the legal damages section. I just spoke what constitutes as legal damages. But these are the types of damages and equitable remedies that should be really fresh in your memory in order to do well on these exams. So the facts, let's read and see what they're saying here. So years ago, Perry purchased two baseballs that he understood were autographed by members of championship teams. One baseball was signed by the Junction City Jaguars, Team Jaguars, and another was signed by the small town Sluggers team, the Sluggers. Because Perry knew nothing about the value of these baseballs, he entered into separate contracts with his niece, Denise, a sports memorabilia expert, to sell each of them. Okay, so just trying to make a mental note here. We're talking about two baseballs, right? And I guess they're worth something because it was signed by Jaguars and Sluggers, right? But Perry knew nothing about the value, but he entered into separate contracts with his niece, Denise, right? So he didn't know the value of these, but he got into uh, a contract with Denise, and he got into a contract with Denise, right? Separate contracts to sell these baseball, right? Aware of Perry's ignorance of the value of his baseballs, Denise told Perry that the Jaguars baseball was counterfeit, worth only $20, right? So let's say that this is the Jaguars and this is the Sluggers. right? Denise told, is it Perry? Okay, Denise told Perry that this was worth, let's write it here, $20, right? Because it was a counterfeit. And Perry sold the Jaguars ball to Denise for $20. So this one, $20. Okay. But in fact, the true value of this baseball was $5,000. So this was actually worth 5,000. But Denise, Perry sold it to Denise for $20. Okay. So obviously, we're gonna probably talk about something like misrepresentation, right? Or fraud. Okay. Denise told Perry that the Sluggers baseball had a fluctuating value and that it could sell for at least 1,000 and likely more. So for Sluggers, she represented that 1,000, that it was 1,000. Denise sold the Sluggers baseball to Bob for 10,000, but told Perry that it had only sold for the 2,000 that she gave him, right? So she represented to Perry saying it was 1,000, but she got it for 2,000. But the actual value of the baseball was 10,000, right? So with the remaining 8,000 that Denise received from Bob, obviously 10,000 minus 2,000 is 8,000 profit. She purchased a used boy car. Ironically, since Denise purchased the boy, interest by collectors in Voy cars has vastly increased, and her Voy is now worth $20,000. So with this 8,000, she purchases a Voy car, and this 8,000 goes up to 20,000. And right away, you should recognize that they're probably going to have us talk about constructive trust and equitable lien, because whenever you have an increase in value, that's when you talk about how for constructive trust, the person who has possessory interest, or the defendant is holding the interest as a trustee because of unjust enrichment, gets to have the increase in value, whereas for equitable lien, there's no increase in value, but if it decreases, the plaintiff can sue for deficiency, right? So right away, I can kind of see where this is going, but let's read on. Denise still has the Jaguars baseball and the Voy car. Okay, so she has this Jaguars baseball and Voy car. Okay. After learning of Denise's deception concerning the baseballs, Perry filed suit against her for fraud. The court has ruled in Perry's favor. Okay, so he sues for fraud, and we don't have to talk about whether there was fraud here. They're telling us that he sues for fraud and he won, right? So they're asking, number one, what damages can Perry recover from fraud? Now, fraud is interesting because usually there are two ways to calculate. The one is benefit of bargain and out of pocket, right? Those are the two main ways to calculate damages for fraud. Now, here, what happened was he represented to um, Denise that Jaguars was worth only 20, right? But the actual value was 5,000. Now, if you subtract 20 from 5,000, that's how you would get out of pocket expenses. And that would be 48, 49.80, right? Now, for benefit of bargain, it would you would calculate that by how much she represented uh, to the plaintiff, how much each of these costs. But before that, we're going to have to do sluggers too. So sluggers out of pocket would be she received 10,000 minus the value that she paid was 2,000. So that would be 8,000, right? So this is a total of 12,980. So that's how you calculate out of pocket. It's basically like a expectation damages, right? Now, benefit of bargain is how much she represented to the plaintiff the cost of these baseballs minus subtracted from the price that she sold it for. Now, because there's no other information as to how much she represented to the plaintiff, how much these baseballs cost, there's not going to be a separate calculation for benefit of bargain theory. So in the end, for fraud, we're going to calculate and say um, she owes him a total of $12,980, right? Um, I will briefly talk about like things like consequential, maybe incidentals. Um, maybe like restitution. Now, consequential, majority of times you talk about foreseeability, certainty, causation, and mitigation. Here, there are no facts indicating that there were any consequential damages, but I would talk about these and say, hey, there are no consequential damages here, so we can't really talk about that. Incidentals, were there any costs associated with the breach of the contract? I don't really see that here, but if there were, he could definitely claim incidentals, right? Now, restitution, it's basically unjust enrichment. I guess this is another theory that I could mention, saying that she was unjustly enriched when she sold the sluggers for $10,000 when she only paid $2,000. So she was unjustly enriched by 8,000. And I would mention that in a restitution theory, right? Just to show the bar graders that I do understand what unjust enrichment is and what restitution remedies, uh, what restitution that a plaintiff in this case will end up with. Now, as far as legal damages, I guess we can talk about punitive. And this is when it rises above the level of negligence, maybe like intent to defraud or malice, right? Now, because there was fraud in this case, um, I guess we can argue for punitive, But one thing about punitive is usually has to be comparable, and it can't be, like $1 million. It needs to, I can't really think of the word right now, but it needs to be comparable to the actual damages, right? I think it was like 8 or 9 times the damages or something like that. So I would mention that here. Here, she has an argument to claim punitive damages so that in the future, other plaintiffs or other persons will not uh, engage in this type of act. So you have to appeal to the court saying that, by awarding her punitive damages, that we're going to make an example out of him and make sure that this basically doesn't happen again. So here we have, we discussed benefit of the bargain, out of pocket. We talked about consequential, incidentals, though these, didn't really apply in this case. You could talk about unjust enrichment, how she was unjustly enriched when she sold it for this much price, and he can use this theory to ask for $8,000 since she already has. She didn't sell the Jaguars baseball; she has that in her possession, right? So to get that uh, Jaguars baseball back, uh, he could argue for replevin because ejectment doesn't apply here. That's getting back possessory interest. So for what equitable remedies, I would talk about replevin for sure. Um, Reformation doesn't really apply, but I would talk about rescission of the contract, whether there were grounds for rescission and whether there are no valid defenses. And one of the grounds for rescission is misrepresentation. So, you basically use the facts, say that because there was misrepresentation, um, plaintiff has a strong case for rescinding the contract. And if that happens, um, he's going to get uh, the baseball back, right? And and whatever he ended up paying her, $2,000, because he's rescinding the contract, he's going to have to give her the $2,000 and he'll receive both one and two. But because number two baseball has already been sold, this is likely not a good theory. So for number two, the court, he's going to have to ask the court to reward him this damages, which amounts to $8,000 for sluggers and this Jaguars baseball bag. Now, constructive trust, we um, kind of discussed it. Constructive trust is when you are tracing the source of this boy car, and that can be traced back to the unjust enrichment, how he was unjustly enriched by that deal. And from that, he's going to be able to trace. And if the value of the void car goes up, which it did at $20,000, he can claim the entire $20,000. On the other hand, when you talk about equitable lien, that's more of a possessory interest. And even if the car value goes down or up, he won't be able to claim that increase in value. So at most here, he's going to be able to argue for $8,000, which was basically what she uh, profited off of Sluggers. But as far as the increase goes, he's not going to be able to get the 12,000 increase. But one good thing about equitable lien is that if the traceable property goes down, then he may argue for deficiency judgment and sue her again to recover for the deficiency amount. So I think that's it for this question. I think the main thing for this question was knowing that for fraud, you have to know that the way to calculate is to use the out of pocket and benefit of bargain, but you also have to analyze consequential incidentals and restitution. And if you have time, or most likely if you can, you want to talk about punitive damages. Now, for equitable remedies, we talked about rescission, temporary restraining order, preliminary injunction, permanent injunction. I didn't really see that apply in this case. Specific performance also, but under unjust enrichment theory, the plaintiff could argue for constructive trust, holding defendant as trustee and tracing so that he can get the increase in value as well, and equitable lien. And under equitable lien, he can, if possible, foresell the property, but he doesn't get the increase in value. But if it goes down, he could argue for deficiency judgment, and also in here, tracing is allowed. And lastly, because she still had possession of the Jaguars baseball, we could argue for replevin to get that possessory interest back. And if that's the case for Jaguars baseball, she'll just get the baseball back, and she would most likely return that $20. And with that, I think this completes another remedies question. And I hope that after doing so many of these remedies questions, that you could, do these now, quickly and to detail. And I hope that my videos on remedies made your life easier. I would suggest that again, instead of doing other things, try to go to the bar website and see what remedies questions were available and just outline them. And don't outline them once, but outline it, rest 2-3 weeks, outline it, outline it again, and repeat that. If you have to do it 10 times until you get it, do it 10 times, because that's what I did. And what's even better is if you can talk about it, discuss it, even if no one's watching your videos. I don't expect anyone to watch, but by me repeating these things, you can't really talk about things unless you understand it. That's why I try to practice orally, in front of the camera, so that it, helps you, but it also helps me. So again, I thank you for watching another video, and I'll see you next time.